Hello, everyone. I am here to talk about the protection of undisclosed information for Philippine corporations. This is one of the topics included in my book, The Protection of Undisclosed Information, published by Rex Bookstore. I will discuss three things. One, the concept of undisclosed information. Two, why is there a need to protect undisclosed information? And three, how do we protect corporate trade secrets? What is an undisclosed information? Undisclosed information is an intellectual property right recognized under the Intellectual Property Code, along with patents, trademarks, service marks, copyright, industrial designs, and utility model. The term undisclosed information is the formal designation given by the IP code. It means trade secrets, confidential information, proprietary information, industrial secrets. These terms are interchangeable and you can use it one over the other without loss of meaning. What are the features of trade secrets? The number one feature of a trade secret is it remains beyond or outside any government registration system, meaning it's not covered by any registration certificate. Because registration requires disclosure, and disclosure is anathema to any trademark secret owner. This is unlike other intellectual property rights, like patents. A patent owner is required to disclose his patentable invention before a letter's patent certificate is granted to him by the Intellectual Property Office. Same goes with trademarks, copyrights, industrial designs, layout designs. The second feature is that the life of a trade secret is not fixed by law. It could last for 1 year, 2 years, 1 hour even, 100 years. The life depends upon the trade secret owner's ability to keep it confidential. Once that veil of secrecy is lifted, the subject matter of a trade secret becomes public knowledge, and it cannot be protected. Anybody can use it. Again, unlike other intellectual property rights, the lifespan is not fixed. For patents, the lifespan is 20 years. For trademarks, 10 years, subject to multiple renewals. Copyrights during the lifetime of the author, plus 50 years from death. Now let's go to examples. A trade secret means different things to different companies. For a big company, it usually takes in the form of research and development. For a real estate company, the sales targets, the training are confidential information and could be the trade secrets of a real estate company. For the bank, cash codes for telegraphic transfer, the vault combinations, salaries of senior officials are trade secrets for a bank. For a pharmaceutical company, trade secrets could be in the form of its drug formulation, secret processes in making the pharmaceutical products, for a pre-need insurance company, sensitive marketing strategies or trade secrets. Now let us go to the second topic. Why is there a need to protect corporate trade secrets? There's only one reason, and that is economic protection. Keeping a trade secret a secret gives a company competitive advantage over its business competitors. And this competitive advantage takes the form of product exclusivity, service exclusivity, increased market share, lesser manufacturing costs, better distribution system, lower production costs, and so on. Now let's go to how do we protect corporate trade secrets? The first one is what I call access restrictions. This could be in the form of putting your trade secret assets inside a vault under lock and key. So it means physical restrictions. If your trade secret assets are saved in your computer hard drive or servers, you can have them encrypted. You can also limit the access by sharing your trade secret assets to a limited number of people. Okay, the second one, which is the common method in protecting corporate trade secrets, is executing what we call confidential agreements. Under a confidentiality agreement, a company binds its officers and even employees from disclosing trade secrets to unauthorized third parties. And there are penalties for violating these agreements, such as termination of employment, liquidated damages, forfeiture of incentives and commissions. These agreements are usually called the non-compete agreements, non-disclosure agreements. The Supreme Court in several cases upheld the validity of these agreements, provided that the restrictions are reasonable. There is a time and place restrictions, usually 2 years. In one case, the Supreme Court upheld the no marriage clause, prohibiting employees of competing pharmaceutical companies from marrying each other. The Supreme Court said that in order to protect the sensitive commercial information and trade secrets of the corporation, that no marriage prohibition is valid. In case the corporate trade secrets are disclosed, and the disclosure can be in the form of intentional disclosure or even unintentional disclosure or negligence, then there are post-disclosure penalties. What are those? One, termination of employment. In terminating a corporate employee, for unauthorized disclosure of trade secrets, a company has to establish three things. One, there should be a company policy prohibiting its officers and employees from disclosing trade secrets to unauthorized third parties. Two, company has to establish the confidential nature of the claimed trade secret. Because if the trade secret is already public knowledge, then there's no need for a company policy to prohibit its disclosure. And the third is the actual disclosure of the employee concerned. Another penalty would be in the form of payment of damages. Company can file an administrative complaint for damages before the Intellectual Property Office, or it can file a civil action before the courts under Article 28 of the Civil Code for unfair competition or for violation of the contract. The company can also file a criminal case under the revised penal code for the unauthorized disclosure of trade secrets. Companies are routinely, now more than ever, required to deal with government agencies. They are required to submit sensitive and even proprietary information for approval, regulatory, or compliance purposes. We have different set of laws for different types of companies for the protection of their trade secrets. For food and restaurant company, we do have the Food Safety Act. It prohibits food safety inspectors from disclosing any trade secrets they discovered during their inspection. For mining companies, under the Philippine Mining Act, the DENR is prohibited from disclosing proprietary information submitted by mining companies. For power producers, under the EPIRA law, the Energy Regulatory Commission is prohibited from sharing confidential information submitted by power producers. If your company is engaged in merger and acquisition and it reaches a certain threshold, you will be required to submit documents, proprietary data before the Philippine Competition Commission. And under the Philippine Competition Act, the PCC is required to keep confidential all those proprietary data submitted by the merging companies. For fertilizer and agricultural company, we do have the Fertilizer and Pesticides Act that prohibits disclosure of sensitive documents submitted before the FDA. If your company is engaged in the building and operating and transfer of government projects, then under the BOT law, all sensitive information shall be kept confidential. The same with government contractor. Under the Government Procurement Reform Act, all information submitted by contractor is deemed confidential and shall not be disclosed to an authorized third party. Same goes true for pharmaceutical company. Documents submitted before the Dangerous Drugs Board If you apply for an exemption or reclassification of your dangerous drugs, you will be required to submit proprietary data. And for a book publisher, the National Book Development Board has the right to investigate book publishers, but they are required to keep all trade secret and confidential documents confidential. They are prohibited from disclosing it to anybody. Again, in protecting trade secrets, my best advice is to keep it simple, follow the golden rule, which is tell no one. Thank you.